Welcome to The Explainer. So, today we're looking at a Constitutional Court of South Africa judgment from 2004 called Zondi v. MEC. Now, on the surface, I know, this might sound like a dry, bureaucratic dispute about some local farming regulation. But trust me, as we unpack this case, we're going to unravel a seemingly mundane local law to reveal these massive, deep systemic issues about history, equality, and the fundamental right to justice.
Okay, let's dive into this. You might be wondering, how exactly does a local disagreement over some trespassing cows escalate all the way to the highest court in the land? It's a fascinating question, right? We aren't talking about a massive corporate dispute or some high-profile political scandal here. We are quite literally talking about livestock. But to understand how this local dispute triggered a major constitutional ruling, we really have to look at what those cows actually represent in this specific context.
To anchor us in the reality of this case right from the start, I want to read you this incredibly poignant quote directly from the source material. It describes the underlying conflict in the region beautifully. One farmer stated, "It is simple. It's a struggle for land, a struggle between the haves and the have-nots. And the haves don't have that much anyway." So you see, this isn't just about animals wandering where they shouldn't. It's about a deeply entrenched historical battle for space, resources, and survival in South Africa.
Part 1, the widow and the warning. To really grasp the mechanics of this case, we have to start with the human element. Enter Mrs. Xolisile Zondi. She was an unemployed, illiterate widow, a fact the court actually noted because she signed her legal affidavit with just a thumbprint. She had lived on Thornview Farm, which was a white-owned farm, for over 25 years with her late husband, who was a laborer there. She had absolutely no land to call her own. Now, take a look at this number. 44,600 rand. This was the conservative estimated value of Mrs. Zondi's entire life savings, her sole assets. And what was it? 28 head of cattle and 18 goats. These animals weren't just property. They were her absolute lifeline. She sold calves to pay for school fees and medical bills. They provided essential food like meat and milk. And crucially, they were necessary for traditional cultural ceremonies and rituals. Her entire existence was tied to this herd. Well, in February 2003, this entire livelihood came under a sudden, intense threat. Mrs. Zondi received a letter of demand from the farm owner, Mr. Cook, and the timeline she faced under the 1947 Pound Ordinance was strict. She had exactly 1 month until March 14, 2003, to remove her livestock from the farm entirely. And if she failed, the very next day, March 15th, her animals would be seized and taken to an unidentified pound. Facing this terrifying ticking clock and literally having nowhere else to take her animals, she sought an urgent high court interdict to block the impoundment. And that move is what ultimately pushed this law right in front of the Constitutional Court.
Part 2, a history of dispossession. To understand why the Constitutional Court took this so seriously, we have to zoom out a bit. The court noted that you just can't look at cattle trespassing on white-owned farms without looking at the broader historical context of South Africa. They had to ask, why did so many landless African people have cattle that were trespassing in the first place? And the answer lies in a century of orchestrated land dispossession.
And this brilliantly illustrates that reality. The historical record analyzed by the court shows laws like the Natives Land Act of 1913 confined the African population, who are the vast demographic majority, to a mere 13% of the total land in the country. Meanwhile, white people owned almost all of the remaining 87%. This engineered residential segregation meant that African people were pushed into these overcrowded, desolate areas that had fundamentally insufficient grazing land for their livestock.
Look at the staggering figure. In the Winan area alone, which is the region relevant to our case, an estimated 22,000 people were forcibly relocated to desolate sites in an area called Msanga. They were completely stripped of their homes and grazing lands, and because Msanga offered basically nothing but desolation, the cattle, just driven by a biological need for food, would naturally stray right back onto their ancestral grazing grounds. The problem? Those grounds were now designated as white-owned farms. So this set the stage for an inevitable, constant conflict.
Part 3. The impounding scheme explained. So the law at the center of all this was the 1947 Pound Ordinance of KwaZulu-Natal. The court meticulously examined how this ordinance ruthlessly functioned against landless stock owners. It went like this. Step 1. Under Section 16, a landowner could immediately seize trespassing animals without giving any notice to the owner whatsoever. Step 2. Under Section 29, damages were assessed by so-called disinterested persons. Step 3. Sections 33 and 34 allowed the pound keeper to sell the animals at public auction to recover fees, and they'd often set reserve prices way below market value. And finally, Step 4, Section 37 allowed any unsold animals to simply be destroyed. Do you notice what is entirely missing here? From start to finish, this entire process completely bypassed any form of judicial intervention or oversight.
Part 4. The hidden racial bias. But you know, the lack of court oversight wasn't even the only issue here. The Constitutional Court then shifted its focus to a deeply embedded racial bias hidden within Section 29 of the ordinance.
So the crucial point is right here in the fine print. Section 29 governed exactly who was legally allowed to act as those disinterested persons assessing the damages. It stated that assessors had to be either landowners or voters as defined by the 1979 Electoral Act. Now on paper, sure, it sounds like a standard legal qualification. But in the reality of apartheid South Africa, the 1979 Electoral Act explicitly restricted the right to vote to white persons only. Furthermore, African people were legally barred from owning the land in question. So by tying the qualification to the Electoral Act and land ownership, the law intentionally and mathematically excluded black South Africans from ever having a say in assessing the damages levied against their own communities.
And the court looked at the empirical data to prove this discriminatory impact. The source notes that between 1990 and 1991 in the winning area, 332 African stock owners had their cattle impounded, compared to just 7 white farmers. It's a stark contrast. Labor tenants on these farms were forced to pay over 105,000 rand just to release their vital livestock. For many of them who had zero cash reserves, it meant the permanent loss of their only asset in a completely rigged system.
Part 5. The right to justice.
Now, because South Africa transitioned to a constitutional democracy, all laws, even these old provincial ordinances, must align with the Bill of Rights. The core of this constitutional clash lies in Section 34 of the Constitution, which guarantees everyone the right to have any dispute decided in a fair, public hearing before a court. The court explained that a modern constitutional state simply cannot allow aggrieved persons to take the law into their own hands. You cannot bypass the justice system to settle a dispute, especially one that is so deeply intertwined with historical social conflict.
Justice Ngcobo, writing for the court, cited this absolutely powerful assertion. The right of access to court is a bulwark against vigilantism and the chaos and anarchy which it causes. Bypassing the courts to seize and sell a highly vulnerable person's sole livelihood, like Mrs. Zondi's cattle, is fundamentally unconstitutional. It basically takes one of the sharpest, most divisive conflicts in society and removes it entirely from the impartial scrutiny of a judge.
Part 6. The court's final verdict. So, how did the Constitutional Court ultimately resolve this? Well, they systematically dismantled the unjust scheme. They recognized that farmers do have a real need to protect their land from wandering animals, but they ruled that the methods used in the 1947 ordinance were entirely disproportionate. Here's the breakdown of the verdict. The core execution mechanisms, Sections 16, 33, 34, and 37, were struck down for violating the right of access to courts. Now, because creating a whole new pound system is the legislature's job, not the judiciary's, the court suspended this invalidity for 12 months to give the government time to rewrite the law. However, Section 29, that rule about who could be an assessor, was declared by the court to be manifestly racist. It violated the right to equality and was struck down immediately.
But the court couldn't just leave a 12-month gap where vulnerable people like Mrs. Zondi could still be exploited, right? So they implemented a brilliant interim solution. Pending the new law, the court mandated that notice of impoundment must be given if the owner can be reasonably ascertained. And most importantly, pound keepers could no longer just sell the animals at will. A local magistrate now had to formally authorize any livestock sales, injecting immediate judicial oversight into the whole process.
So why does all this matter? What's the big takeaway for us? It comes down to this foundational truth. Respect for the rule of law is crucial for a defensible and sustainable democracy. The court proved that there are literally no small or insignificant laws. Even local regulations regarding trespassing cattle must uphold the dignity, the equality, and the foundational rights of every single citizen, especially the most marginalized.
Which leaves us with a fascinating and honestly somewhat unsettling final thought for today. If a 1947 Pound Ordinance in KwaZulu-Natal harbored such profound systemic bias and bypassed the justice system so completely, how many other local forgotten laws still on the books carry the ghosts of history? It's a powerful reminder to always look closer, to question the structures around us, and to realize that the fight for constitutional justice often starts in the most unexpected places. Thanks so much for joining me on this explainer, and keep learning.